Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Let us start. As you know that the Supreme Court is dealing with the appeal filed by a 25-year-old rape survivor who is currently 28 weeks pregnant. The woman approached the Supreme Court after the Gujarat High Court refused her relief. So the petitioner in this case is an Adivasi woman from a remote village in Gujarat and works as a domestic help. It has been alleged that she was subjected to rape under false pretext of marriage. On 7th August, she moved the High Court of Gujarat and sought for medical termination of pregnancy. The High Court directed the medical board to conduct an examination and produce the report in the court by 11th August. The medical board placed its report before Justice Sameer J. Dave of the Gujarat High Court, as per which the petitioner was deemed clinically fit for termination of pregnancy procedure. But the High Court further sought confirmation from her on whether she chose to have the child and keep the child's custody or surrender it to state upon delivery. She denied to accept either of the options and wished to pursue her prayer for termination of the pregnancy. And this was rejected by the single judge at the stage of admission. In view of the urgency, the matter was brought to the Supreme Court. Keeping in mind the urgency of the matter, last Saturday, the Supreme Court held a special sitting to hear the woman's plea. During the hearing, a bench comprising Justices B.V. Nagratna and Ujjal Bhuyan had criticized the Gujarat High Court for handling the matter in a lackadaisical manner. First, the High Court had adjourned the hearing for 12 days despite the urgency of the plea. Later, the hearing was advanced to 17th August and on that day, the single-judge bench summarily dismissed the petition. Today, the Apex Court allowed the appeal and directed the victim to be present at the hospital today or 9 a.m. tomorrow for the pregnancy termination procedure to be carried out. The bench significantly observed that while pregnancy in a marriage is an occasion for joy, pregnancy outside marriage, particularly after sexual assault, is injurious to the mental health of a woman. Also, let me tell you here that last Saturday, after the Supreme Court hearing, the Gujarat High Court had actually passed another order to clarify its previous order of adjournment. The Supreme Court bench today took great exception to this and orally remarked that such counterblast to Supreme Court's orders by High Courts was worth criticism. In a major relief to Delhi's St. Stephen's College, the Supreme Court today refused to entertain Delhi University and UGC's pleas against the college adopting an 85-15 formula for minority applicants. St. Stephen's has an 85-15 formula for admission, according to which, in the result of the entrance examination, 85% weightage is given to the marks obtained in CUET exam and 15% to the performance in interviews. Last year in April, University of Delhi introduced its admission policy according to which the sole criteria for admission to colleges under DU would be the marks obtained in the Common University Entrance Test, that is CUET. In the last academic year, the university and its affiliated colleges were involved in a legal battle over this policy of admission. St. Stephen's also objected to this, saying that it being a minority institution could take autonomous decisions with respect to admissions. When DU's notification was challenged before the Delhi High Court, the court held that the 85-15 formula could be applied only for minority students and not to the others. So, following the High Court order, the process was followed only for minority students. This year, not only has St. Stephen's published its prospectus stating that the formula will be followed for minority candidates in this academic year as well, the college has also challenged Delhi University's notification in a writ petition in the Delhi High Court. Today, the Supreme Court bench of Justices A.S. Bopanna and P.S. Narasimha was hearing the special leave petition filed by the university as well as UGC against an interim order of Delhi High Court allowing the college to go ahead with its 85-15 scheme. The bench said that the High Court would hear the parties' submissions and dispose of the petitions as expeditiously as possible, and therefore there was no need for the apex court to interfere. As you are aware, a constitution bench is currently hearing a batch of pleas challenging the abrogation of Article 370. The challenge of deletion of Article 35A of the Constitution, which granted special privileges to the residents of Jammu and Kashmir in matters of property and employment, is also being heard. Interestingly, a public interest litigation was filed before the Supreme Court seeking a declaration that centre's decision to abrogate the special status of Jammu and Kashmir was valid. At the very outset, the bench comprising CJI Chandrachud, Justice J.B. Pardiwala and Justice Manoj Mishra expressed its skepticism about the nature of the petition. The court observed that the plea was misconceived and a declaration could not be issued regarding the constitutional validity of an action taken by the central government. And now an update on the Manipur violence case and the suo motu cognizance taken by the Supreme Court on the viral video depicting two women paraded naked and subjected to sexual harassment. As you are aware, earlier this month, the Supreme Court constituted a committee to look into humanitarian aspects of the issue, including relief, remedial measures, rehabilitation measures, and restoration of homes and places of worship. The committee is headed by Justice Geeta Mittal, former Chief Justice of Jammu and Kashmir High Court, and comprises Justice Shalini Joshi, former Judge of Bombay High Court, and Justice Asha Menon, former Judge of the Delhi High Court. The committee has now submitted 3 reports before the court. First, highlighting the loss of documents of Manipur citizens in the riots. Second, calling for the Manipur Victim Compensation Scheme to be improved and updated, bearing in mind the NALSA scheme. And a third report proposing the appointment of domain experts for administrative directions. The bench comprising CJI D.Y. Chandrachud, Justice J.B. Pardiwala and Justice Manoj Mishra has directed for the reports to be circulated to the councils and asked them to respond to the proposed suggestions. The bench also noted that certain procedural directions were required in the matter to provide for requisite administrative assistance, to meet financial expenses of the committee, necessary publicity by setting up a work portal, and other infrastructure changes. Attention to all those who forward messages on WhatsApp and social media without reading them or checking them for any abusive, derogatory, or vulgar content. Because no matter who sent you the message or information, if you circulate the same, you can be held liable. The Supreme Court has refused to entertain the appeal by actor and BJP politician S.V. Shekhar against order of the Madras High Court that refused to quash a batch of criminal proceedings against him for his derogatory remarks against women journalists. The cases were registered after Shekhar had allegedly forwarded an abusive and vulgar comment on his Facebook account back in April 2018. Though Shekhar claimed that he had merely forwarded the message received from another person without reading its contents and had later removed the derogatory post on the same day and offered apologies also, but the High Court had said that these acts would not help Shekhar from facing the consequences. That Shekhar was a person of high stature with many followers and he ought to have exercised more caution while forwarding messages. The High Court added that a person forwarding a message must be construed to acknowledge the content of the message. As the person enjoys the likes received on social media, he should be equally prepared to face the consequence if that message has derogatory content. The bench of Justice B.R. Gawai and Justice Prashant Kumar Mishra refused to quash the proceedings against him, however directed that his request to be exempted from personal appearance may be considered by the trial court. In another update, the Supreme Court today dismissed a plea filed by State of West Bengal challenging the Calcutta High Court order which transferred the investigation in West Bengal municipality recruitment scam to the CBI. The background here is that in April this year, the Calcutta High Court permitted CBI to carry on investigation in the municipality recruitment scam. The order was passed on the basis of an application filed by ED claiming that while investigating the teachers' appointment scam, it came across the municipality recruitment scam in the state. As per ED, the two scams were intermingled on account of common agents and common beneficiaries, and that the victim in both the cases was the same, that is, public or common people at large. State then approached the Calcutta High Court to review the single judge order, but the review petition was dismissed. Further, a division bench of the High Court also affirmed the order of the single judge. Against this order, the state of West Bengal moved the Supreme Court. Today, senior advocate Kapil Sibal, appearing for the state of West Bengal, argued that the High Court had erred in its decision of transferring the matter to the CBI, as there was no material to prove that the state could not investigate the scam, that the Enforcement Directorate had no jurisdiction in the matter and the body was just targeting officers at this point. However, the bench comprising CJI Chandrachud, Justice J.B. Pardiwala and Justice Manoj Mishra was satisfied that the teachers' recruitment scam and the municipal recruitment scam were both linked to each other. Accordingly, the matter was dismissed. In another update from the Supreme Court, a bench of Justices Sanjeev Khanna and S.V.N. Bhatti today continued to hear the plea against decision of Patna High Court to uphold the Bihar government's caste-based survey. You know, this verdict was delivered by a division bench of the High Court, which rejected the contention that an attempt to collect data on the basis of caste amounted to a census and held the exercise to be perfectly valid. Today, while the court granted centre permission to file an affidavit placing on record the central government's views on the legality of the survey, but on issuing a temporary halt to the caste survey, the court reiterated its earlier stance, saying that there would be no stay on the process unless a prima facie case was made out. If you remember, in October last year, various videos went viral of an incident of flogging in Gujarat's Kheda district. A group of young men were reportedly brought near a pole where they were subjected to physical abuse. This police action was allegedly in aftermath of the communal clash in Undhela village situated in the Kheda district. It is alleged that some intruders pelted stones at the crowd during Navratri celebrations, and at least 40 persons were arrested in the incident. The division bench of Justices A.S. Supehia and M.R. Mengde had in July ordered the Chief Judicial Magistrate to analyze the pen drives and other electronic evidence, including videos relating to the incident. The direction was made in a plea moved by 5 members of an affected family seeking contempt action against accused police officers. The magistrate court has now reported that videos from the incident involving public flogging were of poor quality, which hamper identification of the accused. However, 4 of the 14 policemen accused in the incident have been identified. This includes local crime branch inspector, sub-inspector, head constable, and a constable. The report mentioned that the face was not shown or side face could be seen in some videos, and that the videos were captured from sideways, which could not be zoomed in. Court said pixelation and low video quality made it challenging to draw precise conclusions. Nonetheless, the court-ordered analysis led to identification of 4 corpses by the victims. To know more about the case, do visit livelaw.in. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.